Title IX Coordinator, Darnell Parker, who will lead off. Thank you.
Good afternoon, everyone. I'm not going to go through every slide in this PowerPoint. I'm just going to hit on some highlights for you so you just get an understanding. I'm actually located in the Division of Student Affairs in the Office of Title IX, but I oversee all of the Title IX functions for the university. So just to give you a clear understanding, Title IX prohibits sex discrimination in all forms of educational programs. This is K through 12. This is also in post-secondary higher education. And it really relies on if institutions are receiving federal funding. Many of you always probably heard in the media, the Office of Civil Rights threatening to take away someone's federal funding if they didn't do anything correctly. It is yet to be done. Title IX and sexual misconduct here outlines ways in which we support students, faculty, and staff at the university while staying in compliance with a federally mandated Title IX. So, to give you an idea of what my office does, because that's something all students and faculty and staff want to know, we came up with a rubric to help you understand many of the services that come out of our office. So for example, under education, we do education around Title IX, sexual misconduct, we do climate surveys, personal safety, navigate other policies, and pregnant and parenting students. All of those things fall under Title IX. Many of you always have heard of athletics being a part of Title IX. It is, but Title IX has always been much more than just a sport or athletic team having more resources than another. We do investigations of sexual harassment. These are all the areas that we look into when they're specifically sex, gender driven. So sexual exploitation, a lot of times you may get a lot of your medical students or faculty who actually may meet someone online and they start sharing personal information with each other, and then that person turns around and says, send me something of you, like nude pictures or something, and then they turn around and threaten to put it on the internet unless you give them something in return. We also do training, so we have a sexual misconduct panel board that oversees all our decisions. Responsible employee mandated reporting. I'm working with the police department here to help faculty and staff understand their role when it comes to Title IX. So some people say, I have not a clue. My investigators are trained through these organizations right here. You have to have a Title IX coordinator at all schools, no matter where. To tell you a little funny thing, many people, I would say as early as 2011, there were a lot of Title IX coordinators, but they weren't trained. They were just appointed because that was their high position. They had not an idea. That's how I got in my role now, not here, but at my last institution. It was our provost. And when they switched, she said, I had no idea I was supposed to do all this stuff. So after the Dear Colleague letter in 2011, that kind of set the stage that these positions need to be on our campus. A lot of our prevention stuff, you're going to hear from my staff about bystander intervention, which is Green Dot. They're going to be coming around to faculty departments to educate them on what that looks like for students. The bathroom posters that have been here since 1994, still going strong. New student modules, even the medical students and graduate and professional students do these modules. And it gives an overview of our policy. We revamped it this year that, unfortunately, my voice sounds very annoying when it's recorded on modules, so poor incoming first year and professional students get to listen to me and my staff for an hour and a half. Title IX brochures will be coming out in August. This will be a quick, handy brochure that you can take around with you. So say if a student comes up to you and say they might have been a victim of sexual misconduct, you can open up that brochure and it will tell you all of the contact pieces, their rights, and it actually gives you a little talk about what you can do. And we are doing a social norming program that will also be starting in September. So you'll be seeing posters around campus that says 61% of our students stated that they don't believe they can do anything about sexual misconduct. But in reality, they can. We're doing Green Dot. So that's going to be a message throughout campus to let everyone know on campus, we listened, we heard what everyone had to say, and this is what we're doing about it. And in this last column, these are all of the resources that we utilize in partnerships. And I will send this to you so you can have this as a resource. Again, this is what sexual misconduct is. The most significant things we see in professional graduate programs is sexual harassment, quid pro quo. If you do this for me, I will do this for you. The example I always give individuals, even faculty, if someone says, if you go out on a date with me, I promise you I will give you a promotion. Now the person might say, I don't want to go out with you, but then they're starting to be retaliated against. Or if the person says, or they're coercing, they keep saying, well, if you go out, I can do all of this for you. That person consents to doing it and then they don't get anything, then that's where we see a lot of our complaints come up. And I had to deal with a couple of those at my old institution with faculty. Intimate partner violence and stalking is the new piece that was added to Title IX as a part of our reporting. Intimate partner violence, the reason why we say it, because domestic violence and dating violence actually have legal connotations to it. We're not the legal field. So we're looking at relationships between individuals that are in a romantic relationship. This does not mean we're going to go to students' houses or faculty and staff and investigate. It's only if the behavior impedes the educational mission and the environment on campus. Does that make sense to everyone? Graduate students freak out and they go, you're not coming to my house, are you? No. Don't have that power. And stalking is another piece of it, and this is what we're trying to educate students a little bit more on. So how an investigation is actually initiated. As a faculty and staff member, you are a responsible employee. And you can make the following reports to the following people. They will report this to my office. This is critical because I know a lot of people get upset about this. I didn't create the law. General counsel didn't create the law. President didn't create this law, okay? This is something that the federal government mandates colleges and universities to do. And the way they look at it is many faculty say, well, I'm going to betray the trust of my student. Well, no, you're not, because we're looking out in the best interest of the student. And the one case I can tell you that happened was a faculty member was informed that a student was sexually assaulted. This did not happen here. The faculty member never reported it to the Title IX coordinator or the chair of their department. That student sued the university. Guess who that lawyer, the student's lawyer, also added to that lawsuit? The faculty member. The student really didn't want to do it, but it didn't matter because that attorney was saying that faculty member was given training and was told they must report it. They failed to do their job. So the reason why we tell faculty and staff to report these things to my office is to protect you. Let me be the one making the decisions on how to help that faculty, staff, or student get the resources they need and how far in the process they wish to go. Does that make sense? So this is not an ego trip. This is something to protect everyone on our campus. You also have to provide me the names of the individuals, the location if it's provided. And I'm going to show you our website. Our website actually has a little list that you can click on, and it takes you through a dialogue example you can have with the student. So you don't have to sit there and try to make it up as you go. This is something that we tell everyone, you have rights through this process. This is critical. And one thing I'll go over real quick, privacy. We cannot promise you confidentiality. Privacy is what we can do. And when I say by privacy, if I get a report about my colleague Peter, I'm not going to run off and tell the world about what was reported by him. Make sense? But we cannot tell people they have to keep things confidential. Available options for resolving the complaint. As many people always think we just have these hearings and everything, a lot of the situations can be handled informally if there's not any sexual violence included in it. So we're talking about sexual harassment a lot of times. Someone said something very insensitive. That is severe and pervasive. Do we need to send that person in front of a panel? Probably not. Is it an educational moment for all parties? Yes. And we can have a conversation about that. The key thing here, people have to understand is you also have the right to have an advisor of choice with you. This is something many people don't like, but guess what? We have to. It can be anyone. It can be someone's mom, dad, priest, rabbi, whoever. And it can also be an attorney. But we can restrict what those individuals do in our process. So we encourage people, if you are going through our process, find an advisor or support person to talk these things through. And we will be training faculty, staff this year on how to be advisors through our process. You also have the right not to participate or make a statement. Many people believe under Title IX you have to participate and tell, you don't, that's your right, but we will still go through our process and make a decision. So this I actually revised to help people get a clear picture of our process, because everyone thinks once we receive a report, people in my office are going to be running around campus investigating and going through people's files. No. As much as I'd like to get them a jacket that says Title IX enforcement, that just really wouldn't be popular. So once we get the report, we do an initial inquiry. We try to figure out whether it falls under the sexual misconduct policy. If it doesn't, we refer it to another process. At that time, we look at interim measures. There can be no contact directives. We can do housing moves. We can do class moves. We can also accommodate assignments, which I know faculty really don't like a lot of times. But we will make those accommodations for the student to say, you still got to complete that work. You're not getting out of it. But we're going to give you a little bit of leeway working with your faculty and dean to make sure that's done. So if it does meet our criteria, then we start interviewing parties and witnesses. We gather the evidence as a part of the investigation, and then it comes to me. I will review the report over and over and over again. If I have questions, I will send it back to the investigators to make sure it's complete. Then we will determine should it go formal, informal, or in the process. And this is where people automatically think, just because we did an investigation, it automatically goes to a hearing. It does not. If we don't have enough information to bring forward to our panel, we will let individuals know that. And then the outcome, informal resolution, which I talked about, it can literally be a conversation. It can literally be sitting down with the individual saying, some of the interim measures we're now just going to keep in place permanently. And that's it. Some other sanctions can actually be under the formal resolution. It can be separation, expulsion, termination, disciplinary probation, in different areas like that. And you have an appeal option. The preponderance of the evidence standard, we don't use beyond a reasonable doubt. We're not criminal. There is talk in the circles that we're probably going to go to clear and convincing evidence after all the meetings our Secretary of Education has went through. I'm not holding my breath. I don't think they're going to touch that. But what the example I give people is, if I am a scale, both parties are here, they're even. Is there enough information to tilt that scale to say someone is responsible? If you don't have enough information at all, it's still here, so we find the person not responsible. Does that make sense? There's a method to it. It's just not a room full of people just going, let me think, responsible. No, we really train individuals carefully to understand that piece. I'm going to go over some other things with you. The resources real quick. These are all of the resources, and we broke them apart for everyone. These resources are confidential. They don't report anything to me or the university. They don't have to. Everyone at the top under non-confidential, yeah, they have to report that to my office. And we have to actually look into it. Now, just for clarity, doctors, nurses, social workers, attorneys that are faculty, you are mandated reporters. Regardless of whether you have a license. Because your students, you're here to teach them. You're not here to take care of them medically or to give them legal advice. And that's how the government views that. So many students would say, well, you have an MD, so I can tell you anything. That's not true. Because you're not in a patient-doctor relationship. Does that make sense to everyone for clarity? And this is our website. There wasn't a website prior to me getting here, but the one thing we did was research with faculty, staff, and students. These are the 3 areas they're mostly concerned about in our process. They're on their rights, what our process looks like, and resources. You can click on that and get all the information you need. Also, at the top under resources and help someone, there is the script that you can click on and review it with the student, and then give you the language to use with that student. And the first thing faculty always say, I don't know how to tell the student to stop talking. It's not being rude, it's just saying, before you go any further, I appreciate you coming to me and trusting me. But now I have to tell you, any information you share with me that may violate Title IX, I have to report it. But let me give you your resources that you can go and talk to someone confidential. And then I tell faculty, if that student still wants you to go through the process with them, go for it. Be their support person. They trusted to come that far to talk to you. Same thing with colleagues. Does that make sense for everyone? Ultimately, the individual controls the process to a certain point where the university still has to ensure the safety of everyone. Any questions? And I will send this to you so you can circulate it to everyone. Yes?
So your point about faculty being mandatory reporters, so I think it's clear with medical students, but what about with health staff who are employed on the hospital side, but have some role as learners even though they're employees?
Can you repeat the question into the microphone?
Sorry, can you repeat it? Because I didn't hear because of the feedback.
Oh, I'm sorry. So my question is regarding faculty as mandatory reporters. It's clear with medical students, which was the example you gave.
Yes.
What about with house staff, so residents and fellows who are employed on the hospital side, but have some learning role?
With us, they still have to report it. Am I correct? They still have to report it.
Residents are not our students, though, correct?
But if they're supervising someone.
Tuition, but they get a certificate with Case Western Reserve on it
Oh,
when they
okay,
graduate.
yeah, then we do have to. I didn't realize our residents got certificates. Okay,
I signed them all.
okay, then yes, report.
Anything else? That was a great question, by the way.
So could you repeat the question?
Oh, sorry. The question was, the medical students understand that the faculty are mandated reporters, but what about other house employees such as residents and so forth? They do have to report things to us since we do sign a certification certificate for them. Yes?
I may have misunderstood something.
Sure.
Let me check on this. I thought that you alluded to some people having a role of ombudsperson. No?
No.
No, people, say if a faculty has a question but is afraid that by going to you it starts a process which you are mandated to follow. If I want to speak to somebody who is knowledgeable but is not mandated to act, to whom can I speak at the university?
What I've told faculty and staff they can do is they can still call me and they can give me a scenario type situation of, yeah, hypothetical. And they don't normally give me names. They just say, what if a incident happens? So I give you an example. Someone said a student disclosed in the assignment that they were sexually assaulted 5 years ago prior to attending Case Western Reserve University. Do I have to report something like that? And I said, well, no, you don't, because it wasn't on our campus, but thank you for still calling to just run that hypothetical by me. Does that make sense?
I'm not sure. I will have to reflect on this. I'd like to be able to speak to people without any consequence and any report, and then decide whether to go to you.
So the confidential resources thrown out, do they need people that?
Not really. They can be. The only problem with that is they're going to just direct you to my office and say, you know, you can still talk to us about it. And I get your dilemma, and we're all having that dilemma right now. But the issue is, if you call me and if you give me vague information, there's not enough for me to go on, number one. So I'm not going to pressure you. Number two, the issue we're finding is faculty are saying, and staff are saying, well, I don't think this should go to that person, so I don't want to report it. And then that's where we get ourselves in a little bit of trouble. Does that make sense? So even though you don't want to bring it to my attention until you run it by people, and at the end of the day, I still need to get a heads up on something just to give you the all clear. Because I'd rather them say, you talked to me, and I said, off your hypothetical, no, there doesn't seem to be there. I had that conversation with a faculty member yesterday. They said, run an idea by you. I said, go for it. They ran it by, I said, nope, doesn't fit under our policy. And they said, okay, thank you. And they said, well, who can I speak to in conduct? So I referred them over to our student conduct office. And I still don't know the names of those individuals.
But if I speak to you, there is a record that I spoke to you.
Yeah, but it's in my office. It's not going to be given to other people. I think the fear in Title IX is once it's told to me, everyone's going to know. That is false. What I keep in my office, I keep close to the jacket unless people need to know. Does that help?
Yes, but you as a university.
Yep.
Okay.
Because again, my job is to protect you and the students and staff. If I don't have the information, I give you an example, Penn State University with the child molestation situation. That never touched their Title IX coordinator's desk, and they went through a lot of coordinators. So that coordinator could have told them, you know, you may want to do X, Y, and Z. And this is how you should handle it. Even if they don't want to speak to me personally, I have a diverse staff that I can send them to and say, if you're uncomfortable talking to a male, you can go and talk to one of my staff members who are female. Or we link them up with an advisor sometimes so they can talk these things out. The Women's Center has a gender violence prevention and response advocate there for both sides. They can actually talk to them and they can tell them what their next steps are confidentially. Do not have to report it to me. Cool? All right. Thank you all. Sure. Just click out. I don't know why he brought mine up first. There you go. I had to use the arrows left and right.
Left and right to advance, okay. Okay, so Darnell just spoke to you about the Title IX portion of the presentation. I'm going to change gears a little bit and talk about a different topic, which is, we've called it the ADA here, but basically disabilities and protections for persons with disabilities, both in the employment context and in the education context when it comes to students. All right, this is the university's non-discrimination policy, and this identifies the different categories of individuals and the different individuals who have protected status under the law and under our policies here. And I think the university policy actually goes a little further than where the law stands right now in terms of gender identity, sexual orientation. The university is, included that in its non-discrimination policy, even though the status of that under law is still up in the air. And so you'll see sex is in there, and that falls under Title IX that Darnell talked about it. Disability is also a protected category, both under the law and under the university's policy. One of the laws that requires us to provide protections to persons with disabilities is the Rehabilitation Act, and that's because we are an institution that receives federal funding. So because of that, there are certain expectations and requirements that we're subject to. The other, and what more commonly is referred to, is the Americans with Disabilities Act, and that's because really the Rehabilitation Act looks to a lot of the standards and definitions that are set forth in the Americans with Disabilities Act. So really both laws apply to us, but more often you hear people talking about the ADA. So this is how the law defines a disability. It's when someone has a physical or mental impairment that substantially limits one or more of their major life activities. So a minor impediment, a minor impairment does not necessarily rise to the level of a disability, and it has to impact a major life activity. It could also be someone having a record of such an impairment. So an example of that would be, say, you have someone who had an addiction to alcohol, but they have gone through treatment, they've recovered, and so they're a recovered alcoholic. They have a record of having an impairment, of having an addiction, and sometimes this is one that often get overlooked. Perhaps you find out in the course of interviewing that, oh, I hear this person used to have a drinking problem, not sure we really want to hire them because what if they still have it, or what if they relapse, and I don't want to deal with someone who has that kind of problem. Excluding someone from consideration based on that record of impairment would be discrimination. Or think of the case of, someone went through, had cancer and went through treatments and has been in remission, is doing fine, but you might think, oh, this is a very stressful job, and if I bring this person into the job, their health may suffer, and maybe their cancer will come back, and I wouldn't want to do that to them, so I don't want to put them in the position. That also is not a valid consideration under the law. That should not be considered when looking at that person as a candidate. And then regarded as having such an impairment is you think that someone may have a disability, but in fact maybe they don't. And the most obvious example on that tends to be mental illness. So you may think someone, oh, I think maybe this person suffers from bipolar disorder or depression or this, and then you start making assumptions about that person because you think maybe they have this condition, but they don't really have that condition, or maybe it's a different condition, and you're making assumptions about them related to what medical conditions you think they may have. So this is what major life activity is defined under the law. And as you can see, it includes a lot of things, a lot of just very basic things, including concentrating, thinking, communicating, working. And if a condition affects a major bodily function, then you all are the medical professionals, so I don't know if they left any bodily functions out of here, but it seems to me like they pretty much covered all of them. So the definition of a disability is fairly broad. So it captures a wide range of people. So what's required under the law? And what's required is that we don't discriminate against persons with disabilities, that if someone discloses they have a disability and they may need some accommodation, either in their work or in their educational program, that we engage in a process with them to understand what is your condition, how is it impacting either your ability to do your job or your ability to complete the requirements of your educational program, and what might we be able to do to adjust things so that you can successfully continue to do your job or to do your program. And that's what you hopefully get to, is a reasonable accommodation that doesn't impose an undue hardship on the institution. And again, when you're talking about a reasonable accommodation, it does have to be reasonable, and sometimes what is determined to be a reasonable accommodation isn't necessarily the first choice or the preference of the individual with the disability, but it's what, based on this interactive process, you come to as the most appropriate and the reasonable accommodation. The other obligation under these laws is to maintain the confidentiality and privacy of people's medical information and their medical records. And we try to discourage people from sending their medical records to their supervisors, or if it's students, to their direct faculty members, and we have other offices where we're trying to have that information go and where that's going to be stored. But should someone share notes from a doctor or something like that, keep in mind now that you've come into possession of someone's medical records, and it's best that you probably get that to the appropriate office, and in the meantime that you're taking measures to treat it as private and confidential. And the last thing is you don't retaliate. And that's if you need to give someone an accommodation, you can't be resentful of the fact that an accommodation had to be made for a person and start treating them differently and less favorably because of that. Or if someone raises a concern that they feel they were discriminated against because of a disability, whether ultimately that concern was with merit or without merit, you can't then retaliate or act adversely against that person because they raised the concern. Here are some examples, and these are just examples. This is not an all-inclusive list of the type of impairments that would qualify for protection under the disability laws. So I wanted to focus a little bit on the employment context. So a reasonable accommodation is making an adjustment either to work expectations or work policies or a work schedule that is going to allow them to still perform their job and perform it successfully. And it can run the gamut. There's no prescribed accommodation. Oh, if someone has this condition, this is what we do to accommodate. It's really on a case-by-case basis, trying to understand what's the condition, how does it impact this individual, what does it limit them in doing, and what can we adjust that will allow them to keep doing the job. So it may be making facilities accessible or moving someone's location so that they can access it easier. You know, if they're in a wheelchair and they're in a building with stairs, obviously something has to be done to get them in an office location that they can maneuver to. Sometimes modifying a work schedule, altering your policies, sometimes some adaptive equipment can be a reasonable accommodation. Restructuring a job, sometimes you make some changes to a job, but what is not required is you don't have to eliminate an essential function. So if you have someone who is performing a receptionist duty and they say, I have this condition that makes it really difficult for me to communicate with people and interact with people face to face. Well, that's kind of a fundamental part of being a receptionist, to greet people and interact with them. So if that person's not able to do that, then they are not really qualified to do that particular job. There may be other jobs that they can do just fine. That particular job, they're not qualified to do. Leave without pay, and this is something we're seeing increasingly. There's the Family Medical Leave Act. So in employment, people with serious health conditions under certain situations get 12 weeks of leave. Often, depending on the condition at issue, 12 weeks is not enough for someone to get treated and come back full force and be ready to jump right back into their job. While the law requires that if they can't return after the 12 weeks, instead of simply saying, we gave you 12 weeks, that's all we have to do, now you're out of a job, we have to look at, is there some accommodation that can get them back to work? And maybe it's giving them a little more time beyond the 12 weeks to be able to get back to work, or maybe it's coming back on a reduced schedule until they're able to work up to full strength. Reassignment to a vacant position can be a reasonable accommodation. That's usually one of last resort, because effectively you're not helping them do their job, you're finding a different job. And that only works out if you have an available job for which they're qualified, and that's typically not the case. We're not under an obligation to create a new job for someone that fits with what they're able to do. So here's, if you manage or you're a supervisor, or maybe you don't, but you have a colleague approach you and say, hey, I've got this situation, what am I supposed to do? These are your obligations as a manager or supervisors, to work with HR and OIDEO to say, look, there's something going on here. How do we need to address it? And often it comes up, maybe you have an employee who used to have good attendance and now they're regularly showing up late. And they finally say to you, I have this health condition, and because of it, I'm having trouble getting up in the mornings and getting to work on time. Okay, they've now disclosed, I have a medical condition that's impacting my ability to arrive at work at time, and that would trigger the process to say, okay, let's look at, is there something we could do? And it's not something that you have to do on your own as a supervisor. You would go to OIDEO and they would help you work through that process and find out, and they have the leeway to probe a little further and say, do you really have this medical condition? Is difficulty getting up and getting to work on time actually a symptom of that condition, or is this not really caused by a medical condition and there's something else going on? Sometimes it comes up, someone's having performance issues. Maybe there's a number of assignments that are not getting completed on time, and supervisors reach the point where I need to write this person up because they're not getting their job done. And in the course of that, when they see now that their work performance has suffered so much that there's a disciplinary consequence, they may disclose, I'm having trouble getting this done because of this medical condition that causes X, Y, and Z, and that opens up the discussion. And if people are disclosing that type of information to you, what your responsibility is to get HR or to get the OIDEO office involved to help guide you through what is the process. So just a little quiz. The purpose of the ADA is to guarantee jobs to all people with disabilities. Who would say that that is true? And who would say that that is false? Right, so that's false. It does not mean that every person with a disability has a right to a job or even a specific job. It's just if you have someone who is otherwise qualified to do the job, you cannot disqualify them based on the disability, and there's an obligation to provide accommodations if that will help them do the essential functions. If you think an applicant or employee has a disability but it's not obvious, you should always ask them about it. Be proactive. Find out what's going on. Okay, on that one, that's false. If someone obviously has a disability and you know if they're in a wheelchair and you realize, oh, the office location this person was going to be assigned to is not accessible, maybe I should raise it as an issue or proactively try to find them a different office. That would be fine. But if it's not obvious that the person has a disability, it's not appropriate to pry. This again goes to the confidentiality and privacy issues. But if they disclose it, then at that point there would be some action to take. And there are ways, as people come into employment at the university, they're asked on their employment application if they have a condition for which they may need an accommodation. So they have an opportunity at the outset to identify that. Once they are hired and brought on, there are ways for them to voluntarily disclose to the OIDEO department. So they have those means to do that. Then I wanted to focus a little bit on how this plays out in the student context. The mission here is to help our students with disabilities fully participate in their enrolled programs and activities, both in didactic work, preclinical, and clinical work. And that's obviously, I think, relevant to School of Medicine in particular, because the clinical skills and the clinical education is important to the overall program. So this is the interactive process, and we have through the Educational Services for Students Office, they have a department dedicated to disability resources. So that is the department, that's the area of the university this process would take place through. And what they do is they receive the accommodation request, they get whatever information from the students and from their medical providers that's pertinent to the condition and to what they're seeking in terms of an accommodation. They'll look at it. They do a lot of benchmarking with what do other schools do with these types of disabilities in these types of situations. They also look at, are we somehow, if we make this accommodation, are we fundamentally altering the program? Are we sort of carving out a necessary skill and excusing them from that because we don't have to go that far? Or is allowing this student to engage in certain clinical work going to put patients at risk? Because that's also something we don't have to do. Accommodations do not go that far. And as part of that process, they're kind of getting all this information on the back end, and then at some point they will engage with the faculty members to get the faculty members' perspective and input on how can we accommodate, here's the suggested accommodation, is that feasible, how are we going to implement it, how are we going to make it happen? So the faculty role is to help in identifying here's what the learning objections are, and can those still be achieved by some alternative means? So here's the standard process, the standard class, the standard way we do this, and it's got a specific learning objective. And just saying, well, everybody else has to do this, this student should too, is not enough and is not the appropriate response when you're dealing with accommodation. The appropriate inquiry and review is, can we still achieve this learning objective, but maybe get there or do it in a different way than we typically do with most students? Again, here's Disability Resources' role, and I think sort of at the end, ultimately they make the final determinations, and if an accommodation is requested, they also document this in writing in case the student decides to appeal it or pursue further action. Dealing with the health sciences, with School of Medicine, there are still considerations of what's an essential function. So if in order to practice a particular type of medical procedure, a student has to be able to do X, Y, and Z, that's taken into consideration. And maybe allowing a little more time than the standard for the procedure, maybe that's feasible, or maybe because of patient safety considerations, it's not. Like I'm thinking about a procedure maybe where a patient's under anesthesia. There's probably a window of time during which it's safe to have the patient under the anesthesia. But if a student can't perform the procedure within that window of time, then we have to look at really, is this something we're going to be able to accommodate, because we can't keep a patient under beyond that window of time without jeopardizing the patient. Again, patient safety is important, and it is taken into consideration, and our Disability Resources Office is well in tune to that, and they've worked with different individuals at the different schools on sort of what are the technical standards for clinical skills. I think, since I'm talking to medical professionals, sometimes in these situations it may be hard to separate what you know as a medical professional from your role either as a teacher or a supervisor. And when it comes to dealing with these disability issues, you're not the medical provider, and you need to kind of separate yourself from that role. So you shouldn't make assumptions about a student's capabilities. Don't predict what their success is going to be in the field. I think it's one thing to talk to them and educate them on this is what it takes to perform this job in the real world, but it shouldn't be from the perspective of trying to dissuade them that, well, because of your condition, it's just going to be too hard for you to do. That's a decision for them to make based on understanding this is the expectation in this field of medicine, and here's what it takes to do it. They're in the position to judge, can they meet those expectations? And don't assume that one accommodation kind of fits all. So I know frequently students have issues with ADHD, or they may be on the autism spectrum, or there's, it seems like an increasing number of people are dealing with depression and anxiety issues. And when those students come forward, we work through the process, we come up with an accommodation for them, but it's not, every student with depression doesn't get the same accommodation, because how their condition affects them is really specific to the individual, and what's going to help them navigate and still meet their requirements is going to be specific to the individual. So this is always on a case-by-case basis. So don't assume because, oh, I've had a student with autism and this is how we handled it, I have another one, I'll just do it the same way, I don't even need to go through ESS, I know all this. You still need to go through the process because it really needs to be a case-by-case determination. And the last thing I want to cover again is the confidentiality issue. So I just kind of talked about how frequently it would come up with staff. So you may find it a little frustrating that you have a staff person you're working with and they're going out on a leave, or they say they've been in touch with HR, after there have been some absences or some missing from work. Or you find out they're dealing with GIA and OIDIO about an accommodation and no one's telling you, well, what's their medical condition? Like, what's going on? It's purposely set up that way to protect the confidentiality. So HR is getting medical documentation from the doctors that's verifying, yes, they have this condition, yes, they need to be out for this amount of time, and the amount of time they need to be out would be shared with you, but the underlying condition is not. And that is because the smaller the circle is on who has that information, the better we can do on really protecting and preserving the confidentiality and privacy. So they're not playing games with you, they're not trying to be vague, they're just trying to respect this aspect of the law. If you have a staff member who discloses to you that they have some sort of medical condition, you should not be sharing that with others, except as you may need to go to HR or OIDIO to seek guidance on, now they've disclosed this to me, how should I handle this? And I think most frequently what comes up is someone receives an accommodation and their coworkers notice, well, things seem a little different for this person over here. They have my same job, but they're allowed to have a flexible schedule and I'm not, or they don't have to do this piece of the job and I do, or they got this special chair and I didn't get a special chair. And they may raise it or they may comment on it. And intentions may be entirely well-meaning to say, look, this is why they're getting this different treatment, but you really aren't allowed to disclose that this person has a disability or that this is happening because they're getting accommodation. The most appropriate response is to say, this is part of fulfilling our requirements under federal law. I'm not permitted to talk about another employee's personal matters with you, and should you have any private or personal matters of your own, rest assured that I will also not share that information with your coworkers. With students, I think keep in mind that if you're going to have discussions with them about medical conditions or struggles they're having in a coursework or a clinical component that you want to have those discussions with them somewhere in a private location. You don't want to have it with them, at the end of a class lecture as all the other students are walking out of class and may overhear what's going on. That wouldn't be appropriate. You want to have a separate meeting with them where it could be more private. You shouldn't identify students in the class who need accommodations to other students in the class. And if you're sending communications to a group of students with disabilities, you shouldn't include them all in the to list. So we've seen this often. It comes up in the context of testing accommodations. Perhaps as in accommodations, people are taking a test at a different time or a different location with a proctor. And sometimes a mass email will go out to that group of students letting them know, here's where your testing room's going to be. But you've included all of the students, and so now they can all see who each other are. And now they've identified, oh, here's another student with a disability, here's another student who's getting accommodation. And so those communications should be done in a way where you're not, it's sort of undisclosed recipients or BCC who all they're going to, so it's not disclosing it to everybody else. And finally, why does all of this matter? And I think, to me, it boils down to a few things. First is reputation. So your school has a fabulous reputation, and you want to keep it that way. You want to keep it being a reputation that is open and welcoming to all types of people, and that meets its obligations under the law, and that plays into recruitment. If you get the reputation for not doing well with accommodating students with disabilities, you may lose out on some very significant recruits just because you get the reputation of not dealing well with someone who might have a learning disability or a depression condition or something like that. It also can impact research. So as I said, the Rehabilitation Act applies to us because we get federal research dollars. And I know from being in the General Counsel's office, sometimes funding agencies will send questionnaires and ask questions about, how many lawsuits has the university been subject to? Has the university been subject to charges of discrimination? One of those being disability discrimination. So that's information some of the funding agencies are asking for. I haven't had to personally complete a grant application, but it may be for some grant applications that may be information that you would be asked to disclose, and that's factored in, and you want to be in a position to say, we're compliant, we do these things, we're not, getting hit with slews of charges or investigations for disability discrimination. And that also goes to risk, because not only could it impact research proposals, but not handling these things well and not going to the resources to get guidance could get you in a situation where you're being met with allegations of disability discrimination and lawsuits, and that's not productive for anyone. It's going to distract from what you're trying to do and accomplish in your day-to-day work. And finally, I will give this to Dan, but so that's kind of the main message. Don't go this alone. If you have these situations, reach out and contact people to get the guidance you need. And here's some of those resources. So if you're dealing with faculty and staff, OIDIO is the Office on Disability and Accommodations. Gia Adine works on staff matters. Donna Davis-Reddix works with matters that pertain to faculty. For students, it's the disability resources within ESS. And also here within School of Medicine, I know Dan Anker's office will direct you to the right resources if you reach out to his office, and the same for the Office of Faculty Development and Diversity. I know Sanalu would be more than happy to talk to you about it and get you in touch with resources to navigate these situations. And I think we have maybe about 2 minutes for questions if anybody has questions. And I do want to caution, if you have an individual specific question, if you maybe find me afterwards so we're not unintentionally identifying someone that people might recognize based on the question. So if it's more general questions, happy to answer it, but if it's a question specific to an individual that others might know, let's save that for a private discussion. Yes, sir.
I believe you used the term disability resources office. Is that the same as HR, or is that something different?
It is something different. So when I talk about disability resources is the office specific to students. For faculty and staff, I talked about OIDIO, which is the Office for Inclusion, Diversity, and Equal Opportunity. They work closely with HR. So often these issues first come up with the HR office, but if it becomes apparent to the HR, the employee relations individuals, this is a situation where someone may need an accommodation, then they will refer it to OIDIO. So certainly HR is definitely a resource as well. It's just the process may ultimately not go through their office, but they're aware of identifying the issue and sending you to the right office. Any other questions? All right, well, thank you for your time today.